Hi,
Hi.
hi. My name is Luis. I'm going to be your tech support for the
Oh,
session.
great. Okay, good. I'm glad. I guess I'm the
Yeah,
first one.
yeah.
Uh, I
You're the
was
first.
worried. So,
No, yeah, you're the first one. I don't have anyone in waiting room currently right now.
okay, great. Well, it's very early here on the East Coast, so I just want to make sure I was up and ready to go. So, looks like I
Yeah,
am.
but I don't know what to call it, early or late for me. For me, it's 2 a.m. right now.
Where are you? Where are you in California?
No, I'm in Mexico.
Oh, wow. Okay, I'm in Florida, so just
Mhm. Yeah.
the way, so to speak.
Mhm.
Okay.
So I don't know if you have like any special requirements for the session or.
No, I uh just want to get it over with. I'm just a little nervous, so
You'll be fine. Don't
Whew,
worry, I'm
thank you.
sure. Okay, Kimberly Graham, is that a part of the session? Is she part
Uh,
of the?
Kimberly Graham. I mean, I know who that is, but I don't think she's a presenter.
Okay, so I'll leave her in waiting room then.
Oh wow, she's on? Okay, I know who she is. I think she's in Berlin.
Okay.
And you can hear me okay. I'm not too loud or anything, right?
Yeah, I hear you perfectly fine. Don't worry.
Great. Okay.
Yeah, okay. So we'll just wait
Mhm.
for the rest to join.
Yeah, I'm early, but better early than too late. I
Yeah,
wasn't
yeah,
I wasn't sure if there was like a separate link for people who were presenting, so I didn't see one. So I was very worried. So I thought, well, I'll just get on early. So I think
yeah.
there's
It's just
not.
it's the same link. Don't worry.
Okay, good. See if that's too bright. That's too And are you timing it so we know when we should stop talking, or should we try to keep an eye on the time? Or
I can time it if you want to.
no,
Like,
I know Stavros had it like broken down and
uh-huh.
like 2 minutes per panelist or something like that for the first inter. So I just want to make sure I don't like keep talking or something. So
Yeah, yeah. Like maybe when they all join, like we can talk. Like I also saw like they had broken up the session like into different sections. So
oh mhm.
well, I'm not sure. Like maybe when they get, they can explain better. Like if they want me to time it or anything. Like
Yeah, yeah.
if
I
you
don't know
prefer.
how that's gonna work, but I just don't want to keep talking and everyone's like, shut up, So
Yeah, yeah. No, no problem. So just to be sure, you got the link right? Like you had this link to
uh-huh.
join.
Yeah. Mhm.
Like you got it to your email, I
Yeah.
think.
Mhm. Mhm.
Okay, just to be sure.
Yeah, actually, it came. I think I had one before, but it came again last night to my Johns Hopkins email. So, but this is the right one, right?
Yeah, yeah, that's the
Okay,
one.
that's good. As long as it's correct, then. Oh, okay. There's Dr. Letter.
Hello. Just
Hello.
testing my microphone. Hi, Maria. How are you?
Oh, Britta. Nice to meet you, Elizabeth.
Good
Pleased
morning.
to meet you, Miss Renato.
Good morning,
Good morning.
Elizabeth.
and Good afternoon. I'm not sure. Probably for you it's good afternoon, but it's about 5 o'clock in the morning here.
Oh, poor you. No.
Yeah, that's okay.
And are you in Geneva, Maria?
No, I'm in Helsinki.
Oh, okay. Oh, yeah, of course. I'm so I thought it was yeah, I thought it was another time of the year. Sorry. But I guess you're busy with the work for the ILC.
Actually, I submitted my final report last night. So
Oh,
this is
congrats.
perfect timing.
Yeah. Oh, that's great.
And how are you?
Yeah, no, I'm all right. Bit tired of the whole pandemic situation, but I think I'm not alone, so
Mm,
I guess one should not complain.
right. And you must have been busy also organizing this panel and the conference.
Yeah, I have not been so involved in the conference except for this panel, so I should not complain. So it has been fine. Yeah,
Mm,
but it's very nicely organized. I'm very impressed by the all the like the facilities of the conference and how
right.
well it's been done, despite the fact it's online.
Yes. I'm very sorry about having missed the previous 2 days, but this has been for obvious reasons.
Yeah, you had a little bit other things to do.
Yes, especially as the Secretariat's report containing all the comments and observations. I got the advanced copy a week ago,
Mm,
and that
wow.
amounted to most part of the almost 1,000 footnotes.
Oh my
So
God.
it has been a lot of technical work.
Oh God. Yeah, I can imagine. And the report for all the states and there was also organization that must have been like
Oh
huge.
yes, I was very positively surprised by the number of organizations, and
Mm.
everybody has made very substantive comments.
No, but it seems like it has engaged a lot of states and organizations, which is positive.
States, it's always quite a limited number of states commenting on the ILC products, but it was more than usually this time. And then, of course, many more states commented orally in the sixth committee. But
Yeah,
many
because
don't
yeah.
simply have the resources to produce written comments.
Yeah, because that was my question. Like, so states do write written statements in addition to the oral comments, then.
Yes, that's the normal procedure. There's always 1 year about. This time it was longer to produce written comments on the draft provisions and commentaries,
Yeah.
whatever the subject.
Yeah. Oh wow. Wow. Well, we look forward to read your report, Maria.
It should be available quite soon.
Oh, that's great. Yeah.
I noticed that my colleague Dira Tladi, who was also secondary.
To give you a warm welcome to this roundtable discussion focusing on the role of international law in protecting the environment in times of armed conflict and post-conflict. And we have an excellent panel that we are very grateful that you could make it, and we really look forward to hear the discussion. But before we introduce you, I would just want to say something about the roundtable. And perhaps I should also introduce myself and Stavros. It's the chairs of the law interest group that is organizing this roundtable discussion. My name is Britta Sjöstedt. I'm a senior lecturer at Lund University, and I've been following this topic for quite some time. And I think that also applies to the other chair of the law interest group, Stavros. Perhaps you want to introduce yourself.
Thanks, Britta. I'm Stavros Pantazopoulos. Indeed, I have also been researching and working on the topic for the last couple of years. I'm currently a postdoctoral researcher with Toxic Crimes Project at the University of Helsinki, and a researcher at the Asser Institute in the Athens Public International Law Center. But as Britta said, my research is on the legal aspects of environmental protection in armed conflicts.
Thank you. And before we introduce the topic for the roundtable, I just want to remind all the participants that by registering and participating in this event, you agree to abide by the UNPAC's anti-discrimination, harassment and retaliation policy. And we put a link in the chat so you can have a look at the policy if you would like to. So before we get into the discussion, I just want to set the scene a little bit. So this roundtable aims at exploring the role of international law and how it can be useful in protecting the environment in times of armed conflict and peace building. And when we speak of international law, it's important to be mindful that this is a system that is very state-centered. It's created by states for states, and this has an impact on how international law, how it looks like, and what we can do with it, which are the limitation of it. It's also a decentralized system, so it has many different fields that are regulating different aspects. So for instance, we have international humanitarian law or law of armed conflict that regulates armed conflicts. We have international criminal law regulating criminal responsibility of individuals. We have environmental law that deals with not just environmental protection, but also other aspects of sustainable development and equity. We also have human rights law, protecting human rights. So this is a field that has connecting a lot of different topics. So when we speak of protection of the environment in times of armed conflict, we need to address several of legal fields, which can be a bit tricky. And it's also a bit tricky to make sure that states follow these rules. So these are two things that we probably need to address during this conversation, how we make international law being enforced on states, but also how we deal with non-state actors such armed groups and corporations. Just before we let the speakers come in, I would just want to mention something about the rules we have for protecting the environment in times of armed conflict. There are not that much that for a long time we didn't have much to work with. There are some rules from the 1970s that protect the environment in warfare from long-term, widespread and severe damage. So that leaves much things aside that are not regulated by international law in times of armed conflict. But we have seen many significant developments in this area this last decade, and we have many initiatives, and several of our panelists have been involved in developing these initiatives. So for instance, we have the 28 draft principles that were adopted by the UN International Law Commission, the ILC, and we have both the special rapporteurs that have been working on these principles, so we can get some insight from this work. And what is quite unique about the ILC principle is that they look at rules of all fields of international law and how they apply during the whole conflict cycle. There is also other initiatives from, for instance, the International Committee of the Red Cross, the ICRC, has published a revised version of their guidelines for military manuals. And we have linked both of these, the ILC principles and the ICRC guidelines in the chat, so you can have a look at them during the discussions. And there are also other initiatives addressing watering conflicts, the humanitarian consequences of conflict pollutions that other panelists that are here today have been working on. But one of the problems is that these initiatives, the ILC draft principles, they are not going to, or it's very unlikely that they will become an international legal convention. So that is another questions that we need to talk about, how we actually enforce these initiatives and how we make states and non-states actors comply with them, and if there's alternatives ways to do this. And I will now give the floor to Stavros that will introduce the panelists.
Thank you, Britta. Yeah, let's move on to the introduction of our distinguished panelists. First, I would like to introduce Marie Jacobsson. Marie is the Principal Legal Advisor on International Law at the Swedish Ministry for Foreign Affairs. She was a member of the UN International Law Commission from 2007 to 2016 and Special Rapporteur for the topic protection of the environment in relation to armed conflicts. Then I will introduce Marja, her successor in this special rapporteur position. Marja Lehto is an ambassador and a senior expert in public international law at the Ministry for Foreign Affairs of Finland and adjunct professor of international law at the University of Helsinki. And as we mentioned, she's the current special rapporteur on the ILC topic. Our third panelist is Daniela Dam de Jong. Daniela is an associate professor and director of the LLM regular program at the Grotius Center for International Legal Studies at the Leiden University. And then coming from the civil society front, Doug Wire. Doug is the research and policy director of the Conflict and Environment Observatory, an NGO aiming to raise awareness of the environmental impacts of armed conflict. Our fifth panelist is Martin Nino. Dr. Martin Nino is a reader at the Faculty of Law and the Institute for Environmental Sciences at the University of Geneva and lead legal specialist of the Platform for International Water Law at the Geneva Water Hub. Last but not least, Elizabeth Hesam is an environmental attorney, a faculty lecturer for the Johns Hopkins University of Environmental Policy and Environmental Security, and author of many articles on Afghanistan, Afghan law, natural resources, and armed conflict. Thank you all for being here with us. It's really a pleasure and an honor. And after this brief introduction, I would like now to kick off the discussion with our first introductory question, which will be addressed to Marja and Liz. Before posing the first question, just a reminder to our audience that you can pose your questions in chat, and if possible, indicate the name of the panelist to whom they are addressed. Alternatively, of course, you can also raise your hand and we will give you the floor or the screen to pose your question directly. So let me start with the first introductory question. This is addressed to both Marja and Liz. It's a more general question. It's about international law. Do you think that international law is adequately equipped to deal with environmental challenges related to armed conflict? And following, depending on your reply, of course, which would you say are the main gaps of the existing normative landscape? The basic key gaps you could identify. So this is a question to Marja and Liz, and Marja, I would like to kindly ask you to kick off our discussion.
Thank you. Thank you, Stavros. Obviously, there's no way to give an affirmative answer to this question, but let me begin by saying that international law is much better equipped for this purpose than was generally considered only 10 or 20 years ago. The ICRC has done a great work with the updated guidelines in revealing the potential of many principles and rules of IHL, International Humanitarian Law, which primarily, of course, were designed to protect civilians, but they also may provide protection to the environment, and this is what the ICRC guidelines reveal. The ILC draft principles, they have a broader focus on the entire life cycle, as Rita said, entire life cycle of armed conflicts, but they contribute to the, or seek to contribute to the same objective. But yes, Stavros, there are quite some problems. Protection of the environment from the dangers of war is not a new concern, but it has been addressed quite sporadically. The legal developments with regard to the prevention and remediation of conflict-related environmental harm, they have largely, you can say, followed their own logic with little connection to the parallel and spectacular growth of international environmental law. If you compare this to the important developments that have taken place with regard to the greening of human rights, with the recognition of an independent human rights right to healthy and sustainable environment last year as the latest step, there's much more uncertainty regarding the interconnections between international environmental law and the law of armed conflict. And this is one reason, in my mind, why there's still no coherent legal framework for the protection of the environment in and in relation to armed conflicts. And as for specific gaps, let me just mention the uncertainty regarding the rules that apply in non-international armed conflicts, the problems of implementation, and the huge accountability gap with regard to states, non-state armed groups, international organizations, companies, and individuals. The ICRC guidelines and the ILC draft principles have addressed some of these, some problems, but not everything. Much remains to be done.
Thanks, Maria, for briefly outlining the capacity potential of international law to respond to these challenges. I would like now to pose the same question to Liz. So Liz, what do you think? What would you add to Maria's reply?
Well, first, I just want to reiterate that I think that international law has made huge advances over the past decade, in part due to the amazing work of Dr. Leto and others. I think there's still gaps. I think looking at climate change as a threat multiplier, whether international law is the right forum for that, I don't know, but perhaps looking at that, and especially the pre-conflict period, might be something that could be explored. And I also think that implementation, international law, and enforcement are two areas where, again, that needs to be further explored. And I think that there's a lot of issues related to gender that perhaps aren't fully explored yet in international law. But I do think the draft principles, if they are implemented into national law and enforced, go a long way to closing some of those gaps. So I think we're on the right trajectory.
Thank you, Liz. This was a positive note to keep us going. So now I would like to turn to Mara and Daniela. If you agree that international law is not sufficiently equipped to deal with these challenges, do we need to clarify existing rules to adapt new law, or rather we are in need of better mechanisms to enforce it? What is the appropriate way forward in your view, and what are the main attendant challenges of each endeavor? Clarifying the law, adapting the new law, or coming up with and strengthening mechanisms to enforce the law? What would you think? Where should we place our emphasis? And I would like to start with Mara.
Many thanks. I'm honored to join this panel. So I try to do my homework with the questions. So regarding the clarification of the existing rules, I think that the academic community has an important role to play in the research on the linkages between the different areas of international law, so namely international humanitarian law, human rights law, and international environmental law. So as Britta mentioned at the beginning, no, international law is a decentralized system, so we have these different areas of international law. So how not to apply them in a situation of armed conflict and in post-conflict settings. Then I think another dimension that is important to clarify, it is not the so-called direct, indirect, and reverberating impacts from the targeting of military objectives and the impact, and indirect impacts and reverberating impacts that can have on the civilian population and civilian objects. So I think that this aspect should be clarified, and we need to know that the lawyers really also work with other experts from other disciplines. Then I think that for the clarification of existing rules, of course, institutions like ICRC, ILC, of course, they have played an important role to clarify these norms. And then I think we should also think about the mechanism like the International Court of Justice or human rights mechanism, also that in their case, they can clarify these rules applicable in international or non-international armed conflict. But of course, the challenge in the clarification of the existing norms, it is that we have a practice that is very limited on the interpretation and the application of the law. So regarding the second approach, adopting new law, I think I'm quite skeptical about this, especially because the atmosphere, the current atmosphere on multilateral negotiations is not really easy not to facilitate this kind of endeavor. But at the same time, we can have other types of new laws. So it is more the kind of soft law instruments. So, for example, we can have no political declaration that can be adopted in this field. And for example, in this context, I would like to mention the draft political declaration on strengthening the protection of civilians from the humanitarian consequences that can arise from the use of explosive weapons. And in this declaration, the question of the environmental protection is addressed, and really it shows how the environmental impact are an additional factor to the suffering of the civilian population. So I think that it is important also to work on this linkage between environmental impact and human suffering of the civilian population. And then, so for the third approach, the mechanism to enforce the protection of natural environment, I have already mentioned some examples like the International Court of Justice or human rights mechanism, but maybe a field that we should focus more, and some organization they are already doing this. It is really not to work with the armed forces, not to review their practices, their military manuals, and to include this aspect related to the protection of the environment. And also another aspect that it is very important, it is that the training of armed forces includes also the aspect related to the protection of the environment. So I think that we often focus on the enforcement mechanism at the international level, but we should also look at the domestic practices, in particular military manuals, domestic frameworks, and how not to incorporate also the developments that they are taking place at the international level, to include them in the domestic good practices. Thank you.
Thanks, Mara. That was very concise. Daniela, what could you add to this? And I saw that the focus, or at least these are the elements I singled out from Mara's response, were the focus on soft law instruments and the domestic component of implementation. Do you see a value in there? Do you see that the future lies with these two elements, soft law and the domestication of all these international initiatives? What is your take on this?
Well, I think, thank you first, Stavros. I think soft law does certainly help in any case to give guidance to states and non-state actors about, best practices and what is expected of them. But of course, it has inherent limitations. So in that sense, I think the actual problems that exist in the current framework cannot be exclusively solved through soft law, but I don't think that is what Mara was advocating for. So, I mean, I think the ILC principles, for example, and the ICRC guidelines as well have done a good job in any case, clarifying that parts of the environment are a civilian object and therefore are in principle not susceptible to be a military objective. But of course, there are a number of situations where the environment is a military objective. And especially there, I think there are major problems with the current framework because when the environment is a military objective, there is no clarity about what kind of harm you can inflict on the environment, or in any case, what would be a sort of max in terms of harm. Britta already mentioned, of course, the additional protocol 1 with its very high threshold, so widespread, long-term and severe damage. And there is absolutely a need of clarification, but also other provisions such as, well, what if a certain area is used for hostilities and it therefore becomes a military objective? Can you then, for example, bomb agricultural areas where this directly has an impact on livelihood opportunities of people? And I think if you look at the current framework, there are also gaps there in terms of what you can attack and what not. But what I feel is even more problematic, in addition to that, is that there's simply very little rules available to regulate non-state or internal armed conflicts. And so for international armed conflicts, we do have something, but for internal armed conflicts, it's even less so. That applies to attacks and rules such as the prohibition on starvation, which is quite narrow, but also in terms of natural resources exploitation, for example, which is a very common practice by armed groups. There are no clear rules on whether or not it's allowed, what are the parameters, while we know that this is a major cause of environmental harm. And so in that sense, there are gaps and they are not easy to solve. First, because it's a politically sensitive area. And second, also because armed groups and regulating armed groups has its problems in themselves, because armed groups are, well, a very diverse group. And so you cannot say armed groups cannot be compared. There are armed groups that have been active for years, that have a sort of control over territory, for example, but there are also armed groups that are, well, hardly organized. And so how do you deal with that? And especially the accountability gap that Maria already mentions.
Thank you very much, Daniela. I have questions also for Doug and for Marie, and this doesn't really perhaps go on talking about non-state actors, but perhaps more the role of soft law and what a mechanism can do that are not like hard binding law. And with the upcoming UNEA 5.2, the fifth session of the UN Nations Environment Assembly happening in less than 1 month from now, and we also have the Stockholm Plus 50 meeting that is fast approaching. Does this topic of environmental protection in relation to armed conflict, does it rank high enough on the agendas of the international community? I don't know if Marie, if you want to go first, and then Dog.
Thank you, Britta. Well, I was expecting a totally different question, some totally different questions, so I'm a little bit surprised by the one that you posed now.
But Marie, do you prefer to hold on to your answer and we'll let Dog go first, and then I will ask you maybe the questions you were prepared for?
Well, I mean, the responses on my questions that you had indicated will probably follow suit to what Dog has to say about this. So I'd be happy to answer, but let Dog go first, please.
Okay, then Dog, I give you the floor.
Thanks, Britta, and yeah, thanks for the invitation to contribute. Yeah, I guess so. We are following this work and sort of undertaking advocacy in relation to it. It's always looking for opportunities, and I think what we've seen from UNEA 5.2, firstly, it's been disrupted by the pandemic, which is why there's a 0.2 with 0.1 having happened last year and being completely online. That's obviously had a big impact on the scope of the resolutions that are there, but there's very little PEREC at 5.2 in the resolutions that have been submitted. UNEP are sort of increasingly conflict averse. They get quite a lot of pushback from some states doing work around this, and a lot of the focus around conflict in the environment is very much focused on climate security, because that's the prevailing narrative which some countries are particularly keen to pursue. We obviously had earlier resolutions in 2016 and 2017 at UNEA, and both of those did address the PEREC framework. No great moves from UNEP's legal department, and I suppose it's a good example of its absence at 5.2 for a couple of resolutions which are relevant. So Switzerland have the second round of their resolution on mineral governance, and that doesn't mention conflicts at all directly. And obviously this is particularly relevant to Draft Principles 10 and 11 on corporations in conflict areas. There's some potential language around nature-based solutions in an EU resolution on sustainable development, but it will be a sentence potentially, so nothing particularly substantive. Beyond that, what else is going on? There's the Global Pact for the Environment process, which we've been engaging with, which has been a slightly peculiar process, which Mary may want to speak more to, and looking at opportunities to promote PEREC in the context of that, but that's not particularly favorable, and that's kind of linked to UN General Assembly Resolution 73/333 around implementation of international environmental law generally. And I think, as Mara pointed out, the political climate doesn't seem particularly favorable to radical steps forward in implementation of international environmental law at the moment. Stockholm Plus 50, yeah, obviously UNEP played quite a big role in conflicts and our understanding of them over the years, and it's partly UNEP's birthday, but again, it looks like what discussions there will be around climate and security, because that's the picture which is kind of loudest and most visible and has the most sort of backing at the moment. Although, yeah, the problem with that, I guess, is taking this quite narrow view around conflict in the environment, that actually to understand vulnerability in conflict settings, you need to look across all the environmental drivers of vulnerability, of which climate impacts are just one part. So if you are looking for climate and climate security, then you should be supporting PEREC more generally. Again, the agenda for Plus 50 is very broadly written, and it's obviously covering a huge range of environmental issues, so not particularly favorable for attention on PEREC. And then more generally, I guess, yeah, I've been putting together our report on what states have said in their written submissions, and actually feeling a lot more pessimistic about the process than I have done historically. I think we've all been quite optimistic along the way over the years, and also surprised at how far it's gone, and what the sort of quality of the output so far. But I think we're reaching the point where there is a lot of pushback from states. I mean, it's no coincidence that it took the Red Cross 10 years to update their guidelines, because there's not a massive amount of enthusiasm from some states around PERAC. And so I think what we need from the point ideally before they're adopted is for those states who support this process and who support an outcome to really start engaging politically around PERAC and pushing forward this agenda in a more substantive way, and obviously working with civil society, with other stakeholders to bring this agenda forward, because I think we're at the stage where it can't really just be a conversation between lawyers anymore, and it has to be this kind of wider political movement if we want to effectively implement this framework. Thanks.
Well, thank you very much, Doug. Marie, do you want to add something to that? And perhaps you also would like to say something about how the work of the ILC has contributed to push this issue forward.
Thank you. And it's always great to listen to colleagues and their views, and I share very much of the views that have been expressed this far. And I think that, as Maya started to say, the work within the ILC didn't start with the ILC. It started, and you made a good historic background as well, Britta. It started long before with specific conventions, the UNMOD conventions, the articles in the additional protocol, and so on and so forth. And the boom was, of course, in the UN General Assembly in the 90s. But that was when the ICRC first presented its guidelines for military manuals. But then there was a total setback, a total dead end, particularly underlined by the fact that the International Court of Justice had taken the advisory opinion on the nuclear weapons case, because that sort of put a very, very wet hand over all discussions on the protection of the environment. But it wasn't really, and this is the beauty of this, the move forward, I think, because it wasn't really until the Environmental Law Institute, which is an NGO, together with the ICRC, which is not an NGO, but it's not the governmental body either, it's something in between, and UNEP, a governmental body, got together in 2009. And this is, remember this year, because many of you have referred to the last decade, and this is about 13 years ago. And when they started to look on the protection of the environment during armed conflict from 4 different areas, you all know them: international humanitarian law, that is the laws of warfare, environmental law, human rights law, and international criminal law, and came up with the recommendations that the ILC should address it. So this is why it ended up in the ILC. It was an initiative taken not from states, but from organizations. And it was very clear, I think, to the ILC that we couldn't look at this from a silo type approach. We needed to break down the silos, and this is why we adopted the temporal approach. We wanted to expand the matter from covering not only protection of the environment during armed conflict, but also protection. How do you deal with the protection before and after? And this was an approach that was generally accepted, and we had a lot of support, not only by states, but also by the ICRC, by UNEPs, by NGOs, like, again, the Environmental Law Institute, the IUCN, and the Toxic Remnant of War Initiative. And perhaps, as Mara said, and I think I would like to underline this, the useful contributions by the academics were absolutely crucial also in this initial phase of the study. But it was likewise important to find out, when we started to do our research, that a lot of things actually had taken place within the defense sector in individual states, and also in defense organizations such as NATO. And we could use that as an argument when we showed what had taken place when we discussed this with the states, because states cannot negate what they actually already regulate within the defense sector. I don't say it was enough, but I said it was a proof, an evidence of something. And So I think that this also led, of course, to a number of other resolutions in the UNEA. Doug, you mentioned them, and I think they were crucial because one backs up the other, but also the Global Pact for the Environment was really something important in this context. We managed to get in an Article 90, that reminds states about the measures they should take within the framework of international law in protecting the environment in armed conflict. And I can tell you from this that the chairman of the Global Pact wasn't very happy with this. He thought this will never survive, but it did survive, and it's there now. So I think that is what I would like to say. I'd be very happy to also address what were the main problems with the topic, because there are problems, but I don't know if I should do it now or I should wait.
Thank you, Marie, and thank you also for bringing up the Global Pact, which is an extremely important contribution here. I think perhaps you can say something briefly about the main difficulties with this topic, and both within like the ILC, but also outside, like if you want to share some of your insights there.
Well, I think that, and I think that one of the main topics that I needed to avoid was to address nuclear weapons specifically, and also to avoid touching the laws of warfare, the laws of armed conflict as such. That was a no-go. So the rules that are connected with the laws of warfare needed to be addressed indirectly, not directly. You couldn't go in and change the additional protocol, for example, and you couldn't specifically address nuclear weapons, which some states wanted to do and others were, needless to say, absolutely against. Within the ILC, one of the main challenges was the article or the guideline. Sorry, the rule on reprisals, which is nothing more or less than what we already have, but that was really, really difficult. The indigenous people's rights was another topic that wasn't very welcome, and it was also very difficult to address natural resources and the sharing and granting access to information, much more difficult than one would imagine. And I did not raise the issue of occupation because the time wasn't ripe at all. And as I think that Maya has done a marvelous job in managing to get in both occupation and natural resources into the topic as we have now. I did not so thank you, Maya, for this success that you had in including occupation and natural resources. I also avoided addressing gender as a specific aspect and tried to build that in the comments, and I think that Maya has taken a similar approach. We couldn't have that as a specific problem, a specific aspect, an aspect that was not integrated with everything. I mean, all this should be viewed with the lenses of a gender perspective, I think. Thank you.
Thank you. Thank you very much, Marie. We really need to know how we ended up here, the trajectory of these draft principles, give both the historical account and then the historical account of the process in general and of the ILC principles in particular. I would like now to focus on the way forward and pose a question to Marja. So Marja, what do you think would be the most challenging part for the principles in the future, and why? And in connection to this, when would we be able to consider the ILC principles as a success story? What are the benchmarks?
Thank you. The most difficult parts, it's always difficult to say beforehand, and relating to what Marie just said about nuclear weapons, I can add that state comments, the written comments the Commission has received from states have brought in nuclear weapons now at the stage of second reading. And that's mainly in their arguments against what the Commission has already adopted. So I have had to deal with the nuclear weapons in my report, which I actually submitted yesterday. On indigenous peoples, I never understood the difficulty with the topic. And as I have been reading the earlier years' comments by states, discussions in the Commission, I understand that there was a difficulty in understanding how the topic of protecting the lands and territories of the indigenous peoples, how it related to the topic as such. So it was related to a very narrow conception of the topic. And I thought I should somehow, either in the report or elsewhere, point out that 80% of global biodiversity, according to some research, resides in the lands and territories of indigenous peoples. So if this topic does not have a connection to protection of the environment, then I wonder what does. Coming to your question, I believe there will be a number of difficult issues. All the comments we received, I always said that this consultation period, the Commission invited states, international organizations, and others to send in written comments on the draft principles and commentaries. And this, I think, was a success. It was quite inclusive as was possible. And we received a huge number of different comments. It has been an embarrassment of richness as well, but we received a number of comments, but all of them were not positive. And a few states that really have a different conception of the role of the protection of the environment in armed conflicts than from the conception that the Commission has had and the Commission has promoted. They have put in a lot of arguments against the Commission's approach. And it may be that some of these arguments are taken on board in the Commission's debate, as also always happens. So it will be, I believe, a challenging debate, but at the same time, I'm convinced that the whole Commission has the firm intention to complete the second reading this year. Also in view of the fact that this is the last year of the quinquennium and next year there will be a new Commission. But I should also mention what comes after the Commission's session this year. It's equally important what happens in the General Assembly. And for the benefit of those who don't perhaps know so much about the ILC, I would like to add that while the ILC is an independent expert body, it's also part of the institutional UN system for the promotion of the progressive development and codification of international law in accordance with the UN Charter. And in that sense, in practice, it means that the ILC regularly reports to the General Assembly and gets regular feedback from the General Assembly. This interaction between the states and the ILC is extremely important. And now that we hopefully and most likely complete the work on this topic and give our final outcome to the General Assembly, it's really important that this final outcome gets a positive response in the General Assembly. In 2019, after the first reading, more than 50 states addressed this topic in the GA, I hope. And then most of them viewed it fairly favorably. And I hope this will also be the situation this year. Did you, Stavros, also ask about the success? What would be a success?
Yes, just a brief remark. What is your criterion according to which
Yes.
you could assess the effectiveness of the principles?
I believe that the draft principles have already contributed to sensitizing states to the environmental impact of conflicts and to the relevance of international environmental obligations, even in situations of occupation or armed conflict. I think we should recall that a number of these draft principles are formulated to give quite concrete guidance to states and other actors, specifically asking states to take legislative or other measures to enhance the protection of the environment in relation to conflicts. The commentaries as well highlight opportunities for enhancing the protection. And as Mari already said, a number of the draft principles are based on what states already do, reflecting and encouraging an emerging practice. But it's not only about states. In general, the draft principles apply to both international and non-international armed conflicts. And one of the clear challenges after the finalization is to raise awareness of them among non-state armed groups and maybe persuade and help them to implement these obligations. And there I believe civil society organizations can play a big role. So implementation is one measure of success. Another measure of success is that the draft principles could acquire some kind of authority, as many ILC products do, and that they could contribute in one way or other to future legal developments. And here I think it's relevant that the draft principles cover quite a number of relevant issues, so that such legal developments could relate to the liability of business enterprises, to peace operations, to removal and rendering harmless of remnants of war, for instance, or to state responsibility. So these are a few examples.
Yes, thank you very much, Maria. Very rich examples and great to hear more about the upcoming report as well. We look forward to that one. I was to relate to the ILC principles. Perhaps Daniela, you would like to say something about how the ILC, how their work could be relevant for the work of environmental peace builders, since I think we are a big group of environmental peace builders here today.
Well, thank you, Britta. I think maybe I should start with saying what the principles do not do, and then what they actually do. So I think an important component of environmental peace building is also engaging with environmental challenges as root causes of armed conflict, and to see if these former grievances over these environmental challenges can be transformed into modalities for cooperation in order to ensure a sustainable peace. And so that's not so much the focus of the ILC draft principles. They do touch upon these issues indirectly, such as, for example, in the principles that relate to status of forces agreements, Principle 6, or Principle 7 on peace operations, where, for example, in relation to peace operations, the principle says that states and international organizations shall consider the impact of such operations on the environment. And so there you can see that this may feed into the discussion on root causes, because that is directly relevant for preventing grievances due to resource competition, for example. But so this is not the primary focus of the draft principles. But then what do they do? And how can they indeed be relevant for environmental peace builders? What the principles do is address conflict-related environmental harm. And I think they've done an important job in actually clarifying that conflict-related environmental harm is not just harm that is the result of an armed attack, so from military hostilities, but that it can also relate to human displacement, for example. And therefore, one of the principles is about preventing human displacement from causing harm to the environment, and also natural resources exploitation as an important cause of environmental harm during armed conflict. And so in that sense, I think when it comes to conflict-related environmental harm, they have broadened this. And also there are a number of principles that deal with how to address such conflict-related environmental harm after an armed conflict, relating to the sharing of information, to remedial measures. I think an important contribution is also in relation to cleanup measures that armed groups are expressly addressed as being also responsible for such cleanup measures. So in these senses, I think they are incredibly important for environmental peace builders. Another issue that I should mention, which I think is really key for environmental peace building, are the principles on corporate due diligence and liability, because these principles deal with preventing that corporations play, of course, an important role in economic reconstruction after an armed conflict, and preventing that such corporations cause harm to the environment, and also calling on states to actually ensure that corporations are held to account and when they have caused environmental harm. So I think those are some of the contributions of the draft principles to environmental peace building.
Thank you very much, Daniela, for this very comprehensive account, which is relevant both for environmental peace builders and other non-state actors, for example, corporations. Remaining on this field of the non-state actors and their role to this field, I would like now to turn to Doug and ask him about the role of NGOs in general, of civil society, in ensuring the implementation of and compliance with the law of environmental peace building, especially with the ILC principles and the ICRC guidelines. And I saw that we've already received a pertinent question in the chat, which is primarily addressed to Marcia, but I would like to hear first Doug's views on this. How can civil society, how can the NGOs contribute to this emerging field? And also, if you could also share what CEOBS, the Conflict and Environment Observatory, is doing in this respect.
Thanks, Stavros. Yeah, so I guess we, well, for many years, I suppose, have been undertaking advocacy around that. And I just want to pick up on something which Maria said, which was around how the process has encouraged states to think about the environmental impact of their operations. And that's really been the case on sort of multiple levels. So, for example, in the UN General Assembly 6th Committee, where these issues have been debated, it has forced states to take positions on these issues, and it's forced them to engage around them. And that's been a really rich, kind of productive process. You can actually start talking to governments about their views on these specific questions, and that wouldn't have existed without this process. One of the other ways civil society can contribute, obviously, these rules are around the conduct of states and non-state actors in conflict areas. So as civil society, we can help monitor that conduct through remote sensing, open source intelligence, and the other methods which we increasingly use to monitor environmental harm and issues in conflict affected areas. Another role we can and will hopefully do more of in future is monitoring practice and encouraging implementation from states. These principles, as Britt has mentioned, they're going to be non-binding recommendations or guidelines, or they're not going to be a treaty. So there's a question of how are they going to be implemented and how can we encourage that as civil society. Another sort of area we can do, which is linked to advocacy, is around norm promotion and diffusion. So that's working across different multilateral fora and processes to promote the Pact principles. And because they're so broad in scope, it brings up a lot of opportunities for how you can do that. So, for example, we've had resolutions at the IUCN World Conservation Congress, We've been engaged with the process which Mari mentioned about explosive weapons in populated areas to highlight environmental issues in relation to that. It's been work to flag stuff on toxic remnants of war at the UN Human Rights Council. We raised the issue of weapons and environmental impact at the General Assembly First Committee. The work at the UN Environment Assembly. There's also good scope for work in relation to the 2030 biodiversity agenda, which is currently silent on conflicts, apart from acknowledging for the first time that conflicts can drive biodiversity loss, but there's nothing in relation to its implementation about support for conflict affected countries. And even in the context of the UN Framework Convention on Climate Change, where we've been working around military emissions, and the draft principles include steps that states and militaries can take before conflict to reduce their environmental impact. In relation to all this, obviously public awareness, it's a relatively small body of people who are working on this topic, who are aware of it. It's not necessarily something which the wider public is engaged with, but there is increasing public concern around the environmental impacts of conflicts, and there's a lot of scope for sort of engaging with the broader publics, which would also be necessary to encourage state engagement on the principles. Just in terms of what we've been doing or what we think could be done and should be done in future in terms of implementation, we undertook a study looking at some kind of implementation vehicle for the principles, because there's not going to be a treaty body promoting compliance. And so as part of this process, we looked at the value of the principles. We looked at how they could be used to influence the conduct of states and also non-state actors, and also looked at the roles of states and civil society in actually implementing them. The first issue is there are 28 principles of vast scope. And so trying to grade and mark states against their performance across all of 28 of these principles would be extremely challenging. For example, there's principles on occupation, but there's only a minority of countries who've been engaged as occupying countries. So it's quite difficult to determine and assess their practice. And we looked into UK practice and Canadian practice on PERAC to sort of highlight issues where it would be problematic to try and implement all 28 of them. And in addition, as Britt has mentioned, the PERAC landscape goes beyond the principles, goes to the ICRC guidelines, and then principles on water and also victim assistance. So you have this quite rich emergent legal landscape around this. So how can you ensure that all the best stuff in these different frameworks is being implemented and engaged on by states? And so I guess the idea we came up with or looking at would be developing a suite of goals and indicators which are based on the principles and these norms, and particularly focusing on those which offer the most protection to people and the environment. This isn't a particularly novel approach. Obviously, we do it for customary law, sustainable development goals. There's no shortage of indicators and suites of indicators which are used, but this could be particularly useful in regard to this. And within that, it's not just the indicators, but also quite practical policy steps towards implementation that states could take and could be fairly reviewed against. This obviously has risks about legitimacy. This isn't necessarily something which states would be responsible for developing, so how legitimate would they view it? Some moaning civil society, haranguing them about their environmental conduct. But there's ways of getting around this through working with states and panels of experts to help develop the principles and indicators. And I think one of the things which is one of the key take-homes from the ILC process is that actually having that process where states are forced to engage and stay engaged on these issues is so important, because otherwise, we end up with a bunch of principles, but there's no ongoing conversation about them. And if states aren't forced to talk about them, they simply won't talk about them because there's no shortage of other environmental issues. And let's be honest, states don't like talking about the war because it's seen as controversial. So how would this kind of look in practice? An online database which would show states' performance on the indicators, maybe up to 10 goals. We'd have annual or biennial reporting, which would encourage this two-way dialogue. We'd be reaching out to states and states would be talking to us and backwards and forwards. State Friends of PERAC group, because obviously a lot of this and a lot of lifting will need to come from governments. If there are governments who are engaged on these principles and on the aims and objectives of the principles, there's stuff which we can do as civil society, but obviously there's a lot more things which states can do because international law is primarily aimed at the state level. And then in addition, yes, kind of norm diffusion, which I mentioned before, about pushing these different implementation measures in different international fora. So as a kind of body of work, there are options of how to kind of work on implementation and to encourage them. And there are other models. So for example, there's the Mine Action Review, which is set up by a bunch of mine clearance organizations. And that's a similar process about looking at how they can implement the Mine Ban Treaty and the Convention on Cluster Munitions. And that creates this kind of process, two-way dialogue between states and civil society, in that case, mine action operators. But yeah, models like that could be quite effective in this context, I think. But I'll leave it there.
Well, thank you very much, Doug, for sharing a lot of the work you're doing in your organization. I see that time is ticking, and we have a lot of questions also coming in from the chat. But I would turn to Mara, and maybe if you want to say, we already mentioned the Geneva list of principles on protection of water infrastructure. If you want to say something more about those principles and where do you think they are heading, like what are the next step? And perhaps if you also would like to answer a question from the chat coming from ICRC, how do you think, or do you think developing regional rules, for instance, river basin level and practices would be more useful in protecting the environment before, during, and after conflict? So I give the floor to you, Mara.
Thank you, Britta. Yes, I think that the Geneva principles on the protection of water infrastructure were really influenced by the work of the ILC, following this approach of before, during, and after an armed conflict. Of course, we had more freedom than the ILC, so we were able not to include all a set of principles based on international humanitarian law. But I think that the added value of this document, it is not to bring together different areas of international law. And so, for example, regarding in particular the environmental damage, we were able not to include a threshold based on international environmental law, so the significant damage. That of course, it is something very progressive in the context of armed conflict. But I think it is important also to have this perception that international humanitarian law, it is not something isolated in the international law framework, but also interacts with other international law fields. So we can imagine also that in a case regarding the environmental damage, the damage can be also read in the context of the developments of international environmental law, and so the notion of significant harm that will lower considerably the threshold of international humanitarian law. So I think that in this sense, the Geneva principles can bring something also in lowering the environmental damage. And then also we brought this perspective of international water law. So in this I also answer to Professor Isegul. So regarding the role of river basin agreements. So to my knowledge, there is only a regional basin agreement that refers to international humanitarian law. So it takes the approach of the Convention on the Law of Non-Navigational Uses of International Water Courses of 1997. But I think that it is interesting that in the additional protocols, so in Article 56 regarding the protection of dams and dikes, there is also a reference that the high contracting parties can conclude specific agreements on the protection of dams. So this, for example, could be a window of opportunity for states, for example, to conclude specific agreements on the protection of dams, and really that dams become included in a kind of list of the objects that cannot be targeted during armed conflicts because of the wide impacts that they can have on the civilian population, but also natural resources. So yeah, I think that yeah, the Geneva principles has the specific focus on water infrastructure and water-related infrastructure, but we tried also to include this environmental dimension. Thank you.
Thank you very much, Mara, also for responding to the question to the chat. And now, Liz, I would like to focus more on Afghanistan, since you've done a tremendous work on researching and writing on these issues. Starting from this premise, from what is happening in Afghanistan and what has happened over the last 20 years and even more, what do you think about the role of international law in addressing the management of natural resources? Can international law as it stands right now afford sufficient protection to natural resources? And at the second level, I would also like your take on non-state armed groups. Many of our panelists brought this issue up. How can the international community engage with them and convince them, persuade them to implement the applicable framework? I think you are muted.
Sorry. Okay, thanks, Severus. I think I'm going to actually address your second question first, because I think it's very, very interesting now. We have what was a non-state armed group, the Taliban, essentially now the state, functioning as the state in Afghanistan. Of course, natural resources have a very long history of funding conflict and armed groups in Afghanistan. And I'll go back decades to the Soviet occupation, when Ahmad Shah Massoud funded much of the resistance to the Soviets through the sale of Panjshiri emeralds. So the history of natural resources goes back, at least 40 years. I think now we're up to 42 years. So, and you're looking now at a state that basically controls a quarter of the world's lithium deposits now, which are going to be extremely important going forward with renewables. They also have extremely large deposits of copper, iron, rare earth minerals that will be necessary. But the funny thing is now the Taliban has to move into a governing position. And there's other non-state armed groups such as ISK, which are mining illegally other minerals such as talc, or deforesting areas. So how can the international community perhaps assist the current government in addressing those issues? I think that's going to be a very interesting question going forward, because if you have illegal mining, say, of talc by ISK, which was, just a few years ago, the Taliban's was in control of that, but now it's another state armed group, non-state armed group. How can the international community address that? And I think that's going to be extraordinarily difficult. But I think the way to address this is through, say, trade regulations and frameworks, such as with certain minerals. And well, let me start with something I'm very interested in, which is the gemstones. So we all know that diamonds around the world fall under the Kimberly process. I think what needs to come about is a similar process for colored stones, because you have about 30 million artisanal miners around the world, of which an estimated 2 million are children mining colored stones. So that's an area that's just coming into development as far as like certification schemes and frameworks to help people who trade colored stones. And you could say, well, what does the Taliban care about anybody, whether it has a certification or not? Well, if you want to sell in certain areas, for example, if someone wants to sell diamonds, they may need to abide by the Kimberly process. So perhaps certification schemes on colored stones could be developed. And I think with minerals, of course, you have the EU Conflict Minerals Act, which is just coming into onto the field. So if, for example, if Afghan miners want to sell to Europe, they may need to look at that. So I think that, of course, we have in the United States the Dodd-Frank Act, Section 1502, but that's more concentrated on other regions. But under the European Conflict Minerals Act, Afghanistan is listed as a conflict affected and high risk area. So companies wanting to do business with them would need to take a look at that. And then of course you have the draft principles 10 and 11 for corporate due diligence and corporate liability. And I think when you have, and no one knows what's going to happen to some of the deals made right before the fall of the last government, but there were some major deals in the work. For example, Fortescue Metals in Australia had just been involved in some negotiations with the Ghani government. And what's going to happen with that, I don't think anybody really knows yet. So I think there's a lot up in the air right now as far as how does the international community address dealing with, first of all, a government that was engaged in these kind of activities over the past 10 years, but now has to govern and now has to somehow deal with other non-state armed groups that are doing this. So I think it's a very interesting situation.
Thank you very much, Liz. I think we are approaching very fast, like towards the end of this session, but I would like to take some of the questions that are posted in the chat. And we have a few questions that are addressing the relationship between human rights and environment, and also how these rights can inform the conduct of IHL and application of IHL rules, and the increased recognition that also human rights needs protection of the environment in order to not be violated. So I don't know if Marie, if you would like to elaborate on that question a little bit.
Thank you very much. I think the question is very pertinent and topical, in the sense that, of course, we know that human rights do not cease to exist just because there is an armed conflict. Let's just start with that presumption. It's just that you may derogate from certain rules. So that's one aspect, and that's something that the ILC has taken into its work, and that really also Maya's most recent report show very clearly. I think the topic that we're talking about, or the issue we're talking about, protection of the environment in relation to our conflict, will be very helped and assisted by the discussions in the human rights context on the right to a clean environment. That is a very, very political issue, and states are definitely not in agreement on how to address this. And because they have different approaches of, if you state that there is a right to a clean environment, whether that should be implementable, to say, in the courts, and how you state this. That's a tricky issue. But the fact that the issue has come up so clearly in the human rights context is, I think, of benefit also for the protection in relation to armed conflict. And this also goes to the fact that we need to address this when we talk about peace building. We cannot neglect the connection between a proper environment and a sustainable peace. So there is a link. I mean, it's a very, very clear link. And it's very sensitive. And many of the so-called, should I say, decent and liberal states are also reluctant to sign on under the legal right to a clean environment. And you know that from those of you who followed the discussions in the Human Rights Council on this, know that this is politically very sensitive.
Thank you, Marie. Yeah, this is a very troubling and burning issue, how to translate international human rights law standards into the applicable legal framework to inform the interpretation or how they directly apply. We have another question from Mononita. Mononita highlights that in countries with armed conflict, affirmative action to protect the environment takes the backseat So now we're discussing about conflict-affected states. So as government or NGO, civil society in general, how adaptive should these actors be to work out these issues, to resolve them at the global level? And at the second level, should these be left to the concerned state, meaning to bring out policy resolutions and resolve?
Stavros, sorry for interrupting you, but you're hardly audible.
Okay, thanks. Many thanks for this. Can you hear me now? Or okay, so it's the question from Mononita. The question is about conflict-affected states and the role of governments, NGOs, and the civil society in general, and what is their role in peace building? Who should have the primary initiative? How could we complement these efforts? And yeah, I would like to, as Mononita says, to focus on conflict-affected states and not in general. Doug, would you like to share your views on this? How could we move forward in practical terms? The conflict is there. Who should take the initiative?
Thanks, Stavros. Yeah, that's an interesting question, isn't it? This is a discussion on international law between states, whereas I think historically there's kind of been this assumption that there's a conflict, everyone stops caring about the environment, local civil society communities don't care about the environment because it's a question of survival and everything else. But actually, your environment is your question of survival, and people do continue to care about the environment. And it's interesting looking at countries affected by conflict where you've seen the expansion of environmental civil society who are day in, day out taking actions to protect their environment, irrespective of what the government does, assuming the government is even in place. Or countries like Libya, where after 2011 you had this huge flourishing of civil society, including many environmental organizations who received support from international environmental organizations on capacity building. So yeah, I think we need to work at all levels on this. There needs to be the kind of high level work which is inevitably going to be done to try and move states. We need to have a lot of work with not necessarily the sort of super high level states, but stuff like the Biodiversity Convention and others to ensure that states are properly engaged on the environment and sensitized to the need for conflict sensitive programming around the environment. And also for the environment to be mainstreamed, as we kind of discussed in the session yesterday, across humanitarian response, development response, and also to directly support civil society and NGOs and communities in affected countries to help monitor their environment and to undertake advocacy on the environment.
Thank you very much. There is a question on the Convention on Biological Diversity from NOR. And they're in their process of finalizing the post-2020 Global Biodiversity Framework, which would set the legal foundation for the conservation and sustainable use of nature and its contribution to people. What opportunities are there for the convention, the framework, to strengthen the engagement consideration with armed conflict, particularly in the light of plans to conserve 30% of the earth by 2030? And I send this out to the panelists that would like to answer this question. Do we have a volunteer dog? Yes, thanks.
I can come in. Thanks, Noah. That's an excellent question. Yeah, it's something we've been looking at and speaking to some conservation charities about. Obviously, no countries met the previous targets, biodiversity targets, and the 2030 agenda is quite broad. In the context of the discussions, which have been delayed by the pandemic, there's been very little discussion of conflict, and delegations who are there don't want to talk about conflict. They don't necessarily see it as relevant to biodiversity. And yet we know that conflict can have this huge impact on biodiversity and certainly on environmental governance, which is critical for supporting biodiversity protection initiatives. The draft agenda, draft framework, for the first time actually mentions conflicts, and that's due to IPBES, one of their reports, which brought in this link between conflicts and biodiversity loss. So it's in there as an indirect driver of biodiversity loss, but there's nothing in the text at the moment about how that's going to be addressed. So for example, there's an annex on gender. So which is going to be supporting sort of gender sensitive implementation of the framework. But there's nothing on conflicts. There's a huge opportunity, we think, for some kind of annex on supporting countries affected by insecurity or conflict to implement the framework. Otherwise, you're going to have a lot of countries who are affected by insecurity and conflict who do not implement the post-2030 agenda. And yeah, as we know, many of those countries are biodiversity hotspots, and yeah, it's just a huge hole really. But again, it's this issue that we have these other environmental processes where conflict and security issues haven't been mainstreamed into those. We spend a lot of time trying to mainstream the environment into security processes, but it needs to go both ways. Otherwise you end up in situations where you come up with a whole post-2020 agenda which doesn't address the very specific needs of conflict affected countries. Thanks.
Thanks, Doug.
Thank you, Doug. Daniela, something to add to this?
Yeah, so adding to Doug, I think, estimations are even that about 80% of armed conflicts are in biodiversity hotspots. So it seems incredibly relevant for the Biodiversity Convention to actually address this matter. So I think, there can be, I think, a sort of a connection between the Biodiversity Convention, also the ILC principles in relation to protected zones. And I think there, the Biodiversity Convention could, in any case, encourage state parties, at the very least, to to think about those zones that are designated as part of this post-2020 framework. To ensure that they also receive protection during armed conflict. I think more generally, but this is going off topic, the whole post-2020 biodiversity framework is also problematic in a sense that if you want to conserve around 30% of land, I can already see new conflicts actually erupting as a consequence of land being dispossessed, etc., etc. But that's a bit of a separate matter.
Oh, thanks, Daniela. Just quickly adding to this, I think especially this point of the protected zones is the primary point of intersection between the two fields of law, IHL and international environmental law. We know from IHL, we are familiar with the concept of demilitarized zones, for example, or non-defended localities, area delimited protection, and the same happens with international environmental law, in situ protection, as they call it, either in the Biodiversity Convention or, for example, in the Ramsar Convention. This is a point of huge intersection, I would say, and many thanks to both of you for highlighting this aspect. Moving now to the final part of our session of this very, very rich discussion, I just have a quick question to all participants, a quick tour de table. What is your key takeaway from this discussion? If any of our participants here ask you, what should I keep, or what should I take with me when leaving? What would you say? What would your response be? And please, I would like this to be something because we're running out of time. If you could just give, your response in 30 seconds, 40 seconds, it would be great. And I would like to start with Liz. Liz, I think you're muted.
Oh, sorry. So in terms of what should someone take away as one of the most important aspects of this discussion, I would say that we are definitely moving in the right direction in terms of filling gaps in international law on the protection of the environment during armed conflict. We're not there yet, but there's very important work being done, and a lot of specific issues in different areas that we're moving in the right direction. That's all I can say.
Thank you. Who wants to go next? Maybe Doug?
Yeah, thanks, Britta. Yeah, I guess my takeaway would be that if we want this PERAC framework to have the desired effect, it's going to need political buy-in from governments. this isn't just a legal question now, it's a political question. It needs to have that backing and long-term engagement and support to ensure that implementation happens.
Thank you. And Mara, please.
Yes, thank you. For me, it was really interesting to hear now and to remember the beginning of the work of the ILC with the role of two international organizations, or ELI and ICRC, as from our recommendation came up this work. So this is really incredible to see how from a recommendation of two international organization came this work. And also I think that the panel also has showed that even if it will not be a binding text, the ILC draft principles, they can have an influence on the behavior of states and non-state armed groups. Thank you.
Thank you, Mara. And Marie, please.
Thank you. I have a few takeaways, but I would like to remind you all of something that we haven't discussed, which I think is sometimes forgotten and very important, and it's the remnants of war issue, the toxic remnants of war, and particularly the toxic remnants and the remnants of war at sea, which is now in one paragraph from having been in two paragraphs initially. And I'm afraid that we run a risk of losing it if we do not show how important it is to shed a light on the importance of that for a sustainable situation at sea. It will have terrible effects. But the takeaway here is, I think, from this session, is that we should bring up this matter in every possible fora, and that we should use facts to argue. The facts like Maya just posted on the percentage of biodiversity in indigenous peoples' areas is a marvelous example. To use the facts as an argumentation, but also to engage local communities, and in particular listening to what women do at the local level in order to protect the environment. And finally, of course, do not ever give up.
Thank you, Marie. I think we give also Maria and Daniela quick takeaways, even though we're running over time, but I think it's worth it. So please, Maria.
Thank you. Referring to what Marie said earlier about breaking the silos, and Doug said about mainstreaming environmental security issues, I think one of the takeaways is that armed conflicts are, even in terms of international law, they are not just about conduct of hostilities. There's a huge number of other issues that are relevant to armed conflicts and very much related to the protection of the environment. Thank you.
Thank you. And Daniela.
Well, I think I would like to simply concur with the important role of civil society, of international organizations, that we need to really make sure that this is on all agendas. And from various angles. I mean, an alternative approach is, for example, the Stop Ecocide Foundation, which is lobbying very hard for the criminalization of ecocide. I mean, it's a different perspective, but it all there are of course synergies, and I think it's important to have this agenda within various fora and from different perspectives.
Thank you. Many thanks, Daniela. Many thanks to everyone. I know many of you stayed up late to follow us because of the time difference. It was a very rich discussion. We really enjoyed it. I hope the same applies to you. We are very thankful, and of course the recording will be uploaded on the YouTube channel of the association. Many thanks, and please enjoy also the rest of the conference. Thanks for joining us.
Bye.
Bye-bye. Thank you very much.
Thank you.
Bye-bye. And thanks.